Good morning to all of you. Welcome to Legal Matters by Sai Babu Sukara. Friends, in the last so many sessions I have been telling you that bail, giving of bail or granting of bail is the personal discretion of the judge. Of course, he will follow the three great principles of justice, equity and good conscience even while delivering the judgment. But normally, giving bail is the personal discretion. When a trial court gives bail, then the High Court cannot put them in fear by giving memo as to why you have given bail. This is what is observed by the Honorable Supreme Court of India in the case of TOTARAM versus State of Madhya Pradesh in criminal appeal number 1010 by 2023 decided just 2 days back on 6/4/2023 by Honorable CJI Dr. D.Y. Chandrachud and J.B. Parthiwala, who deprecated the High Court of Madhya Pradesh very adversely for giving an order, for giving a memo calling for his explanation. It's not that easy to say. Something might have been transpired. What is that? Let us find out. ఎందుకంటే కేసులు పెక్యులర్గా ఉంటాయి. వాళ్ళకి తెలియదు, హైకోర్టు తెలీదా పర్సనల్ డిస్క్రిప్షన్ అని, మరి ఎందుకు హైకోర్టు మేమో ఇచ్చింది, అది తెలుసుకోవడానికే ఈ కేసులా చేస్తున్నాం. గోయింగ్ టు ద ఫ్యాక్ట్స్ ఆఫ్ ద కేస్, ప్లీజ్ రిమెంబర్, మిస్టర్ తోతారాం, he is figured or he is named as an accused in crime number 354 by 2022. Under sections, different, all simple sections, 294, 354, 292, 447 and like that. 354 is the most important section, that's all. Because 354 is non-bailable, they have registered a case. So, this incident took place on 19/6/2022 in an area called as Harda, Madhya Pradesh, right? So, the allegation is when the complainant was driving his cattle to tend his cows and oxen in the fields. He was caught in the middle, he was tied to a tree, he was tripped, he was assaulted and he was beaten. This is the allegation. Case was registered. Fine. Against Totaram and others. And since there are non-bailable offences, normally he escaped the police arrest. He tried to get bail, anticipated bail. He tried because non-bailable section is there, 436, but not given bail. Ultimately, since the trial judge, that is second ADJ, I think he is second ADJ Harda, right? So the second ADJ rejected the bail petition in the first instance, right? In the second instance, what happened is, actually before the second instance, since he was not given bail by the trial court, he approached the Honorable High Court of Madhya Pradesh. High Court also rejected. They did not grant the bail. Once again, after a relevant period of time, కొంత టైం అయిపోయిన తర్వాత, he filed a fresh bail application before the same trial court, requesting to give bail basing on the changed circumstances. What are the changed circumstances? Is the police, they have completed the investigation. They have submitted the charge sheet before the court. So, read 167 clause 2 of the CRPC. When the charge sheet is filed, and the charge sheet cannot be filed within 60 days or 90 days, he has got a right to get statutory bail. Right? Now, the trial court, basing on the changed circumstances and also on the view that the other accused also were granted bail, yes, it has given bail. Against this bail order, the state, that is State of Madhya Pradesh or the police, they approached the High Court. High Court was furiated. What is this? We have already cancelled the bail. How can the trial court give bail? Something might have happened. Come on, call for explanation from the court. This is the result of calling explanation from the second ADJ. Against this, he approached the second ADJ, approached the Supreme Court. Supreme Court please remember, they criticized the order of the High Court because when once they have gone through the documents, that clearly shows that the orders of the trial court does not indicate that the judge applied the wrong principle of fact, principle of law. The other accused are granted bail, the charges was filed, and you all know that bail is a personal discretion. That's why V.R. Krishna here said, bail is a right, jail is only an exception. So granting, that too, granting, there is nothing wrong. Supreme Court did not find anything wrong in granting bail to the accused persons. That too, is it a serious offense? After all, 294, 354 is not a murder case. It's not a dastardly dacoity case. Then why do you call for explanation? Here, please remember, the Supreme Court stated that, please remember, the judges cannot give orders when there is a chilling effect on them like this memo. Right? So please remember, here, 1 minute. Trial judges, yes, same thing. Fresh application, bail out of the trial court, okay. Here, please remember, the wording is, I am not able to see, calling for explanation. Okay. I have seen the Supreme Court Chief Justice of India writing something. I am not able to recollect the same. Because normally in the this medical negligence cases, we have been telling you, a doctor with shaking hands or shivering hands cannot conduct the operation well because of the professional negligence cases. Likewise, if a judge feels that the High Court will call his explanation, then it will be have chilling effect on him. He cannot decide the case freely. Therefore, give him a free hand. The orders of the High Court calling for explanation from the trial judge, they are set aside. And the bail already granted to the so-called TOTARAM stands good. So very good decision. This is the vision of the Honorable Supreme Court of India. Please read the case and enrich your legal knowledge. With this, I am concluding. Thank you very much.